Hello, welcome to Episode 2, Paperless Practice and Technology, continuing our series on RELA, or the Real Estate License Act, and rules. I'm Betsy Urbance, Illinois Realtors Chief Legal Counsel, and joining me in this episode will be Anneliese Fierstos, our legal hotline attorney. So what are the changes in the current Real Estate License Act with regard to paperless practice and technology? To begin with, the definition of license itself changed. Used to be that license was issued in paper and you had a sponsor card and all of these things were paper. And there were long periods of time where if you were a licensee, you would take your paper license to your broker would sign off, then you would go to your new broker and get a new sponsor card. All that under the Act is gone. I understand there may be some residual paper practice happening at the department, and this is to allow the department to change to a more technological approach. But the license law itself says that as opposed to a paper license, it's now a privilege conferred. So if you're licensed, you have a privilege conferred, and your status of licensure will be what is important. How do you prove you're licensed? Well, someone can look you up on a website, and if you want to, it's my understanding that you can actually print a license for yourself to carry on your phone electronically, and maybe even there's an ability to print a paper license. I'm honestly not sure of that, but the most important thing is to be able to prove that you are a licensed person and that you are sponsored by a sponsoring company. Changes that you'll find in Article 5 of the License Act regarding practices in the virtual world. So formerly, we had a very clear definition and requirement for a bricks and mortar or a physical office. All of those provisions could be found in Section 5-45D, described a physical office. The new License Act, or the amended License Act, does not actually require a physical office, but you certainly can have and can elect to practice out of a physical bricks and mortar office. If you do, you have pretty much the same sign requirements, and you have the same requirements that the office, the real estate office, be in a distinct and separate area from any other retail or financial business. But on the other hand, if you decide to have a virtual office, let's say your practice is going to take place through a website. So folks would, when they want to do business with you, they would walk through a virtual office door on your website. In other words, they would sign on, they'd have a username and a password, and they come right into your virtual office. Those situations are now clearly allowable should that be the way you elect to practice in the state of Illinois. Keep in mind that if you operate a virtual office, the agency requirements don't change. You still owe confidentiality to your client. The concept of designated agency is still very much alive. So if you have designated agents in your office representing opposing parties to a transaction, you must have a way, electronically and physically, to protect the confidential information of the opposing clients. Your files must be virtually locked. In other words, not everyone will have access. Similar, analogous to having a general file located somewhere in a physical file cabinet that everybody has access to. You should not have that. Even if you have physical files, that should not be the case in a designated agency office, which is the presumption of how you operate in Illinois. We're negotiating rules presently with the Division of Real Estate within the Department of Financial and professional regulation. And one such rule will be found right now at section 1450.115 that talks about how either a sponsoring broker would terminate sponsorship with a licensee, and conversely, how a licensee would terminate sponsorship with the sponsoring broker. I am going to read that language to you right now. This is a new proposed rule dealing with termination of sponsorship. Number 1, upon termination of sponsorship by a sponsoring broker, the sponsoring broker shall immediately notify the terminated licensee and within 24 hours of the termination notify the division in a manner prescribed by the division. The next subsection deals with when the licensee initiates the termination. When a licensee initiates termination with their sponsoring broker, the licensee shall within 24 hours of termination notify the division in a manner prescribed by the division and immediately notify their sponsoring broker. We're actually hoping that a copy would go to the sponsoring broker, but that's yet to be determined, so stay tuned on that point. Finally, once the sponsorship has been terminated, the license is automatically changed to inactive status, and the licensee is prohibited from engaging in licensed activities until the licensee has established a valid sponsorship with a new sponsoring broker. So those are what the proposed rules should say. And I think the important point to remember here is whether you're the brokerage company terminating a licensee or you are the licensee terminating your sponsorship with your current broker, both has an immediate duty to notify the entity that you're leaving. If you're the person leaving, you have a duty to notify your broker. If you're the broker terminating the licensee, you have a duty to immediately notify that licensee. Now, with regard to names, there's always some question about names and how that works under the License Act, and what are the requirements if you change your name. If you legally change your name and you're practicing under something, you've changed by virtue of a married name or you took your maiden name back, then you would have to notify the department of the change by court order or marital status, and that would have to be noticed up to the division within 14 days. On the other hand, if you're practicing under an alias or a nickname, I'll use the example, my legal name is Elizabeth, I practice under Betsy. I can use Betsy. I need to notify the division, if I'm a licensed real estate broker, that I'm operating under that name. But the caveat here is that if you're doing any official business with the department or the division of real estate, you need to make sure that you're operating in the name in which your license shows. So if my license is Elizabeth Urbance, I need to make sure when I'm doing my continuing education that I use that name so I get the proper credit. Makes sense, right? Now, Anneliese is going to talk to you about offices.
Betsy Urbance was just spending some time talking to you about the changes with respect to offices, the virtual offices versus the brick and mortar offices. Under Section 45B of RELA, there have been significant changes, eliminating the need for a branch office license. Now, the department just needs a list of offices for each sponsoring broker, and there must be a designated managing broker appointed with the department for each office. A designated managing broker is allowed to manage more than one office, but as a factual and practical matter, that designated managing broker must be able to exercise sufficient oversight of the sponsored licensees, including the new broker licensees. Betsy also spent some time talking to you in her overview about the fact that the new act also assigns more responsibility to the managing broker. Now, the title for a managing broker that's been assigned to an office is a designated managing broker. With that new title comes a lot of new responsibilities. As a designated managing broker, that individual is responsible for each of the offices that is assigned with the department to a sponsoring broker. And in that capacity, they need to have the capability to look out for each of that individual branch's office requirements, including overseeing all escrow accounts and overseeing all licensees that would be working under that office. One thing that's very important to remember with respect to all of these changes is that if you choose to change your brokerage structure and office model to include offices that are either virtual or brick and mortar, consult with an attorney. Right now, there are no new rules in place to provide you any more guidance with respect to how to set these up. So you really want to consult with an attorney, have that attorney review the changes under the Act, and get some individual legal advice with respect to the business model that you are trying to establish. This has been Illinois Realtors RELA web series. Be sure to watch our next episode when Betsy and I will discuss licensing and management.